Good morning, everyone, and welcome to today's Beasley Allen webinar, The Past, Present, and Future of Asbestos Litigation. My name is David Byrne, and it's my pleasure to introduce our speaker for this important litigation topic. Today, my partner Charlie Stern is going to explain how asbestos litigation has really become our longest running mass tort in U.S. history. He'll discuss how the process of holding asbestos manufacturers accountable for harming workers has really changed through the decades. And Charlie's going to focus on the state of asbestos laws and litigation in Alabama and in other parts of the country. He'll offer insights into the types of cases that can be litigated here and which cases may become more viable over the next 10 to 20 years. So while we're waiting on the last of our registrants to join us, I want to take just a few moments to formally introduce my friend Charlie Stern. Charlie is a longtime leader in Beasley Allen's toxic tort section, and he currently works out of our Dallas, Texas office. Now, when it comes to representing plaintiffs who've been exposed to asbestos and developed life-threatening cancers like mesothelioma and lung cancer, Charlie's about as knowledgeable as they come. Charlie received his undergraduate degree from the University of Georgia and his law degree from the University of Texas. He's a former assistant district attorney and a national trial lawyer's top 40 under 40 trial lawyer. Charlie has been and remains a huge asset to Beasley Allen, and we are so happy to have him with us today. So before I turn the program over to Charlie, I do need to go over just a few CLE housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State bars for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered, but by the end of this week, you're going to receive another email with a certificate of attendance and an updated presentation and video link. That'll include all of the slide sets that we'll be going over today. You can email that completed evaluation form to webinars@beasleyallen.com. Folks, this webinar is being recorded. So for those Alabama and Georgia attorneys participating by phone, it's really important that you email us your name, phone number, and your state bar ID number to webinars@beasleyallen.com. That'll help us ensure that you receive full CLE credit. Also, I want to recommend to all of you, please check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the year. And I'll tell you, if you just sit in on these webinars each and every month, you're going to go a long way towards fulfilling your CLE credit obligation. Finally, if you got questions during today's webinar, here's what I want you to do. I want you to use the Q&A feature that's located at the bottom of your screen. Look down at the bottom of your screen. You'll see that Q&A button. We're going to set aside time at the end of today's program to try and tackle all of your typewritten questions that come in from you and the rest of your viewers. So with that, hey, Charlie, let's go ahead and get started.
Well, thanks very much, David. I appreciate the introduction. And you're right, today we're going to be talking about asbestos litigation. I could talk about asbestos litigation for days. I'm going to try to keep it to about an hour this morning. So hopefully you guys are going to learn a little bit and understand how much the litigation has changed and how important it is to represent individuals who have been harmed by asbestos exposure over the years. So some of the things that we're going to talk about today, we're going to talk about what asbestos actually is. We're going to talk about some of the diseases that are associated with asbestos exposure, the history of asbestos litigation, the current state of that litigation, and where I see things going in the future. We're going to predominantly focus on mesothelioma today. That's the signature disease associated with asbestos exposure, and it's the disease that I focus on primarily here at Beasley Allen. So what is asbestos? Well, asbestos is actually just a commercial term. It's a group of 6 different mineral silicates, and I have them listed there on the slide. The first is called chrysotile, and that has serpentine in parentheses there because it is the only one of the 6 asbestos mineral silicates that is a serpentine, and that means the way it's formed and actually the shape of the fiber. The other 5 are actinolite, amosite, anthophyllite, chrysotolite, tremolite. And there you see that I have it indicated as amphibole. Those are the 5 amphiboles. The amphibole fibers versus the serpentine fibers are going to be longer, thinner, and more brittle. So what is it about asbestos that makes it useful, or what are some of the characteristics? Well, it's very, very strong. It's highly flexible. It's resistant to breakdown. I'm sure many of you have heard that it doesn't burn very easily, and that's absolutely correct. It's non-biodegradable, it's environmentally persistent, and it's quote unquote safe if not disturbed. And what I mean by that when I say safe if not disturbed is that there is asbestos naturally occurring in deposits around this country and around the world. Traditionally, that asbestos was not and is not dangerous. It's only when you mine, mill, process, and implement that asbestos into products that are later disturbed, causing the fibers to get into the air and into people's breathing pathways, that it becomes dangerous. I have here asbestos. I don't know if you're able to see this very well, but this is actually some serpentine asbestos carefully enclosed and encapsulated in a frame. That is chrysotile asbestos right there. With that in this room, it is not necessarily going to be dangerous. But if I were to start messing with that, pulling it apart or process it into a product, well, then it can become very, very dangerous. And we'll talk about some of those things, some of those dangers that it can cause. But the important thing to know about asbestos are the very things that make it such a useful commodity, or such a useful commodity during the 20th century. The fact that it's strong, the fact that it's flexible, the fact that it's resistant to heat breakdown are the very things that make it so dangerous to you and me. When we breathe that asbestos into our lungs, we can't get it out. And the same things that made it a useful property for industrial products are the same reasons that it's very dangerous for us. It stays in our system, it doesn't break down, and it causes harm over many, many years. So these are 2 of the categories of asbestos that we were just talking about, the serpentine and the amphibole. The asbestos that I just showed you, that's the serpentine or chrysotile. Most of that's going to be mined up in Canada, at least the stuff that we incorporated into American products during the 20th century. And then the amphiboles, that's going to be about 7% of commercial use. And what that means is the other 93 to 95% of all products that utilized asbestos in the United States use that serpentine or chrysotile asbestos. And that's an important distinction for a lot of reasons. But one of the reasons that it's so important is in the litigation itself. There are defendants to this day who will argue that the chrysotile asbestos or the serpentine asbestos, which accounts for 93 to 95% of all products, is not dangerous. They will tell you that chrysotile is the friendly fiber. That's a term that they use. And that we could be inundated with chrysotile asbestos and we would not get sick. Now, no regulatory or health agencies agree with this, and it's obviously not the position of the plaintiff, but that has wide ramifications, that assertion by defendants in the litigation. Because of course, if you're dealing with chrysotile-related products and a chrysotile defendant, they're going to point towards other exposures, potentially amphibole exposures, or anything else as the real reason that an individual was diagnosed with an asbestos-related disease. So these are just some pictures of the commercial grades of asbestos. You have the chrysotile, you have the amosite, and the gracitolite. The other 3 that I mentioned, actinolite, anthophyllite, and tremolite, those are traditionally not used in commercial applications. Now, you might find tremolite contaminated in certain chrysotile deposits, just like you might find anthophyllite contaminated in talc deposits. But traditionally in the United States, we really only used chrysotile, amosite, and gracitolite. Chrysotile, like I said, is the one that's the most common, mostly mined up in Canada. A couple companies, but the big one was Johns Manville that did the mining, the milling, the vertical integration, basically, of asbestos products starting in the 1900s. Then you have amosite. Most of that came from Africa and some other places. And then gracitolite. Gracitolite, as you can see, it's blue. It was called blue African asbestos. Typically, it was found in South Africa. And one thing that I mentioned earlier was the defendant's assertion that chrysotile is not dangerous. And we won't get into the weeds too much on this topic, but even the plaintiff's side agrees that there are varying levels of potency related to these particular kinds of asbestos. Everyone agrees gracitolite is the worst. It's by far the most dangerous. Its relative potency compared to amosite and chrysotile is up for dispute, but we would all agree that chrysotile is the most dangerous, amosite the next most dangerous, and chrysotile, while still a carcinogen, is not quite as dangerous as the other two. So some characteristics of asbestos that make it particularly dangerous. It doesn't have the onion properties. I imagine that everyone sitting in this room has either themselves or been in a room where someone is slicing or chopping onions. When that happens, our body has a natural way to alert ourselves that we don't like the onions, that we need to stay away from those onions. Our eyes will water, we'll cough, it'll be a noxious smell, it'll taste funny, we can taste it in the air. Asbestos, unfortunately, doesn't have any of these properties. So an individual who would be working with it and the fibers become so tiny that they're minuscule, they can't be seen, the body doesn't alert itself that there's something wrong going on. It doesn't tell you that you're going to be working with something dangerous. It doesn't have any of those onion properties, which naturally would lead your body to avoid breathing in the asbestos. Unfortunately, that leads to people breathing in that asbestos. Some facts about mesothelioma that I think are important. If you were in medical school today and they were teaching you about a sentinel tumor or a signature disease, I imagine that the Robbins textbook on medical diagnosis would point to mesothelioma as the prime example of that. And what does that mean? Well, it means that if you see a mesothelioma tumor, you know there was an asbestos exposure. We have all sorts of types of tumors in this world, different types of cancer with different types of causes, even lung cancer, which is so closely associated with smoking cigarettes in pop culture and common understanding. That's not necessarily a signal tumor or a signature disease, because there are many other causes of lung cancer outside of smoking cigarettes. But with mesothelioma, if you see that mesothelioma, you know there was an asbestos exposure. And we've actually gone back and we've had historians look at records predating industrialized America, predating the widespread use of industrial asbestos. And what we see is that we see surgeons, pathologists back in the 1800s describing tumors, talking about tumors in various kinds, whether it's a breast tumor or a lung tumor, or a testicular tumor, all of these things. We do not see them talking about what would be a mesothelioma. We do not see pleural tumors described the way they are now. And that's because prior to the widespread use of asbestos, mesothelioma hardly, if at all, existed. It's only with the widespread use of asbestos beginning around the 1920s that we saw mesothelioma start to pop up 30, 40, 50 years after that. Like I just mentioned, it's going to be 30 or 40 or 50 years after the person works with the asbestos that they're diagnosed with mesothelioma. That's what we call a latency period. Basically, we work with the product, we work with the asbestos, we breathe the asbestos in, it gets caught in our bodies, it gets caught in our lungs, we can't get it out, and it takes 30, 40, 50, 60, sometimes 70 years for that mesothelioma to actually develop. And that's why so many of our clients are, in their 60s, 70s, or even 80s. It's not unusual for someone to have worked one summer job with asbestos in their 20s, go on to be an executive at some company, and then all of a sudden when they're 75, they've just retired, enter their golden years, be diagnosed with a mesothelioma. It relates back to that 50-year-old exposure when they were 20 doing that summer job while in college. So it's progressive. It's always fatal. Basically, you are diagnosed with mesothelioma, and until recently, you had about a year to live. We've gotten some better treatments in the past few years. In 2020, the FDA approved a new immunotherapy that's been, giving people a couple extra months, but by no means is it a cure. It's very painful, and like I said, it's always fatal. And most importantly, in terms of the litigation, it's 100% preventable. And not only is it 100% preventable, it's been preventable since the 1930s. In other words, we've known how to prevent disease related to asbestos exposure since the 1930s. And the same steps and mechanisms and protocols that were suggested in the 1930s, and we'll talk about some of those as we move forward today, that were applicable then, still work now. Still worked in the 70s, still worked in the 80s, and still worked in the 90s. Unfortunately, those mechanisms and protocols were not articulated well to workers, nor warnings given to them on products. So what was asbestos used for, and what occupations were subject to exposure? Keep in mind that today there is not much asbestos that is still currently incorporated into products. There is not an outright ban on asbestos in the United States, surprisingly, but there isn't much that's incorporated because companies basically have decided it's too bad, people know about it, we're not going to use asbestos, no one's going to use our products. They found suitable replacements over the past number of years. But during the 20th century, starting around 1900, as the Industrial Revolution really got underway, we're talking about tens of millions of people who were exposed to asbestos. These were workers, these were bystanders, people who were working around those workers, and these were family members. And some of the most common professions that you would see an individual exposed, well, obviously mining and milling. The folks who are mining and milling asbestos are going to be exposed to asbestos. Friction or automotive, what that means is cars. Cars had asbestos. We had asbestos brakes, we had asbestos clutch facings, we had asbestos gaskets in the engines. So you have all your mechanics out there who are working on vehicles through through today, actually, because you still might have some cars that have old products in there. But traditionally, they were installed through the 70s, 80s, and 90s when they started to, remove asbestos from those products. Construction products obviously had tons of asbestos, whether it be joint compound or sheetrock or shingles, things of that nature. The Navy, during World War II, we had a massive output of naval vessels to fight the Axis powers. One of the things that we utilized on those vessels was asbestos-containing insulation. It was light, it was easy to move, it was easy to install, but it was very dangerous. We don't sue the Navy. That's not something that happens in these cases. Who we sue are the product manufacturers who installed their materials and their products on naval vessels and didn't talk to the Navy, didn't tell the Navy how dangerous this material was. There are companies that made turbines and boilers and pumps and valves and gaskets, all of the internal mechanisms that help make a naval vessel operate. Those are the things that we're talking about. Those are the companies that we sue in these cases. And I've had dozens of individuals who worked in the Navy for maybe an entire career or just 4 years, who are later diagnosed with mesothelioma. Electrical workers, not surprisingly, industrial site maintenance, refineries, power plants. As you can see, a lot of these are just industrial sites, factories, textiles, shipbuilding, going kind of dovetailing with the Navy. That was one of the main areas where asbestos was used historically. I have a case right now out of Mobile involving an individual who worked on ships, helped repair ships all the way through the late 1980s and was exposed to copious amounts of asbestos. And then there are some areas of exposure that you'd never think of, things that just so happen to have been asbestos back in the day. I have a good friend who tried a bowling ball case out in California, got a $5 or $10 million verdict on that case. Basically, the bowling ball company Ebonite was purchasing asbestos tailings from a company called Bendix and using them to make their bowling balls. And you had an individual who would be drilling the finger holes in the bowling ball exposed to asbestos on a daily basis. Everyone remembers tree flock, Christmas tree flock, that white fluffy stuff that you would put on your Christmas tree back in the day. A lot of that stuff was asbestos. Even crayons have asbestos. They sometimes are made with talc, and we'll talk about talc as we move forward. Talc can be contaminated with asbestos, therefore crayons can be contaminated with asbestos. Other things too, like dental tape, but the list goes on and on. In the end, I think there's some 3,000 plus products in the United States of America that one time or another utilized or incorporated asbestos into those products. We have take home there in parentheses. What is that? Those are exposures for people who are not working with the product themselves. Basically, what this means is someone is living at home with an asbestos worker or with someone who works with asbestos. It's a very common scenario. For example, that shipbuilding case I was referring to earlier, the worker comes home. He doesn't know that he's working with asbestos. He doesn't know that the dust on his clothes is dangerous. He comes home, his wife, his son, his daughter, they all cohabitate. People are doing their laundry. They're shaking clothes out. Next thing you know, 30 years later, it's not the individual who was working with the asbestos who's diagnosed with mesothelioma. It's actually the person who was doing the laundry or driving around in the car with them. Those are very common cases, and they've been known to exist in the medical literature since at least 1965. That was sort of the first epidemiological article indicating the correlation connection between take-home exposures, asbestos, and mesothelioma. And then we have talc with an exclamation point. Talc is a big one. We'll spend some more time talking on talc. I think everyone here is likely aware of the Johnson & Johnson world of talc exposures and asbestos and baby powder, but there's a lot more to it. So we'll talk a little bit more about other areas besides J&J. So here are some of the asbestos-associated diseases. We've talked about a few of these, but asbestosis, that is a scarring of the lining of the lungs caused by repeated and prolonged exposures. So you saw this pop up first in the 20s. These were folks who were working in textile mills, who were working with and around asbestos on a daily basis, and they were breathing so much of it that you were actually getting a fibrosis, a scarring of the lining of the lungs that can be debilitating, and it can be deadly. You don't see quite as many of those anymore because it requires substantial exposures, but they still do happen. Lung cancers, that's another one that's associated with asbestos. There's actually a synergistic effect between smoking cigarettes and lung cancers and asbestos. In other words, if you smoke cigarettes, you have an increased likelihood of getting lung cancer. We all know that. If you're around just asbestos, you have an increased chance of getting lung cancer. That's true as well. But if you combine the two, then your odds increase exponentially. So it's important to understand that just because you have a lung cancer where someone may have been a smoker in the past and they were also exposed to asbestos, that doesn't mean outright that the case is not going to be possible. You can still have cases with individuals who smoke cigarettes and then were exposed to asbestos as well. We're going to focus on mesothelioma today. There are really technically four kinds of mesothelioma: pleural, peritoneal, pericardial, and then you can actually get testicular mesothelioma as well, but it's very, very rare, so I didn't list it. The most common is going to be your pleural mesothelioma. That is mesothelioma basically of the lining of the lung. That'll account for theliomas. It's the most common. Peritoneal, that's mesothelioma of the lining of the stomach. So each one of our organs has a mesothelial layer, has a layer around it that basically encases it. And what mesothelioma is not cancer of the lung or cancer of the stomach, it's cancer of that layer. So it's where the asbestos gets stuck, where it becomes irritated, and over time causes the cancer to form. And then we have pericardial. That's going to be about 5% of mesotheliomas, peritoneal being about 20% of mesotheliomas. Pericardial is mesothelioma of the lining of the heart. So the three main ones, you have lung, stomach, and heart, but it's not technically those organs, it's the lining, it's the membrane around those organs. Talking a little bit about pleural mesothelioma, like I was just saying, the tumor arises from the thin serosal membrane surrounding the lungs. I mentioned earlier that it's very invasive and it's always fatal. Like I said, life expectancies have been extended some recently, but that doesn't mean that it's still not always fatal. It's very rare. Mesothelioma, unlike other cancers, we're only talking about 3,000 cases or so per year in the United States. And if you break that down even further, you see that one case per about 110,000 people each year in the United States, and that's with a known exposure. So when you see a mesothelioma, typically, almost always, it's going to have a known exposure to asbestos that you're able to identify doing a work history or some sort of investigation into that person's background. With that said, there are very, very rare instances of mesotheliomas occurring without an asbestos exposure. But you see there, we're talking about 1 to 2 cases per million people each year. So it's very, very rare. You have a much better chance of getting mesothelioma if you're exposed to asbestos than you do if you're not exposed to asbestos. And we talked about earlier the latency period. I have here 30 to 40 years. That's sort of the average, but it can on either end, be as short as 20, as long as 70 in some instances. So let's go back in time a bit. Let's look at a little bit of history of asbestos and asbestos exposure. The first reports of asbestos were causing death. That happened in the early 1990s. In the 20s, we have asbestosis recognized. Merriweather and Price, they were some folks that we'll talk about more specifically soon, who came out with a report in the 30s that basically identified how to protect workers. It's the same tools, or those are the same tools that we can utilize today and that we should have been utilizing for decades prior to today. You have in the 40s the discussion of cancer coming out and its association with with asbestos. Then in 1955, the cancer connection was official. Sir Richard Dole came out with an article. He was an epidemiologist, and he basically showed that based on case control studies, we know that asbestos causes lung cancer. 1960, a similar article came out, but this time about mesothelioma. That was Wagner in South Africa, and he was talking about crucidolite specifically. And then in 1964, a gentleman named Dr. Selikoff, he's sort of the godfather of asbestos medical research. He had been studying the insulators in New York City. He came out with the conclusive report on asbestos, and not just crucidolite, asbestos in products causing mesothelioma, specifically the Insulators Union in New York City. And we'll talk about Dr. Selikoff a little bit more. And then in 1971, 1972, OSHA is established. OSHA is established, and it's still Occupational Safety and Health Administration. It still obviously regulates workplaces today. It was established because of asbestos. The very first chemical property, anything that it regulated, was asbestos. So it was started in the 1970s to help protect workers, namely because of asbestos, and they've added obviously many other things that they regulate. A little bit more on the history. We mentioned 1922, Anna Rinkowski. She's the woman who was first diagnosed with asbestosis. Not first diagnosed, but the first time it appeared in the medical literature was in 1922 over in England. And then we'll talk about Merriweather and Price, Sir Richard Dole, Wagner, Selikoff. These are all sort of the watershed moments in asbestos research, which led to the litigation. 1969, that was the first case involving product liability claims of asbestos manufacturers. Like David said, I'm here in Texas. It was a Texas case. I believe it was Orange County. Ward Stevenson was the lawyer on that case. He's passed away since then. But the plaintiffs in that case were Tomplet and Burrell. They were insulators in an area of Texas which we call the Golden Triangle. The Golden Triangle was a home for many petrochemical facilities, and there was lots of asbestos used in those facilities, so it should serve as no surprise that people got sick there. Then in the 1970s, we have asbestos litigation. It really takes off, including mesothelioma cases. In the 1980s through the 2000s, there was extensive litigation. Obviously, just like every other tort, during the 1990s and onwards, we've experienced a lot of tort reform as well. So this is 1924. This is how far back in time we can look to determine whether or not people knew about asbestos and the hazards. And this is really important. I'm not just showing this because it goes to the history of asbestos. It implicates how we prosecute these cases today. In most of the jurisdictions, in terms of proving negligence, it should have known, knew or should have known. So what we do in every single asbestos case, along with the actual corporate documents that show, a General Electric or a Westinghouse or whoever, an Exxon, talking about the hazards of asbestos in the 40s and 50s and the 60s, we beef up the state of knowledge, the state of the art, by utilizing all of these medical journals and industrial journals going back to the 20s, talking about how if people are exposed to asbestos, they're going to get sick. And it doesn't matter whether they're talking about mesothelioma in 1924, they're talking about asbestosis. They're talking about a hazard. So going back in time, if you were to go into any medical journal or any library in the United States at any university, you would have been able to pull this information. As early as the 1940s and the 1950s, information related to asbestos being a carcinogen was in Encyclopedia Britannica. We are not talking about a secret. We're not talking about something that only a select few knew. It was out there to everyone who wanted to know it, especially industry. This is the Merriweather and Price report. This is the watershed moment in terms of asbestos research, I believe. This was a report done over in England where Merriweather and Price, they examined 363 workers in a textile mill, and they found that 1 in 4 of those individuals had signs of asbestosis. Some of them had worked there for very long, some of them for very short amounts of time, but they noticed that 1 in 4 had signs of asbestosis. And important were not just the findings, but were the recommendations. I mentioned this a few times earlier. Basically, Merriweather and Price said, yes, asbestos is dangerous, but we can eliminate the risk, or at least reduce the risk, by doing some very, very simple things. 1, inform the worker. I think the term they use in this document is a sane appreciation of the risk. You have to tell the worker what they're working with so that they understand what's at stake, so that they understand what steps need to be taken. Number 2, you have to label the asbestos. Number 3, you have to partition people when they're working with it. Always have respirators. Make sure people are wearing breathing protection. Wet down the asbestos. If the asbestos is wet, it doesn't get in the air, and it doesn't eliminate, but it reduces risk of exposure immensely. So these are basic principles. And label the asbestos. If the asbestos is labeled, then workers know that it's there and they can work with it properly. So these were basic tenets that were put out in 1934 that followed basic industrial hygiene tenets that had been available for hundreds of years as to how to avoid exposure to dangerous things. And these are the same things that OSHA basically adopted, much more technical later on in the 70s, but these are the things that protect people from asbestos. There's Sir Richard Dahl. He was an epidemiologist. He's very famous. He studied tobacco, he studied asbestos. He was one of the first men to come up with the notion that tobacco and cigarettes can cause cancer. He was also one of the first men that came up with the notion that asbestos can also lead to cancer as well. And that was in 1955, like I said. Irving J. Selikoff. I don't have a picture of Dr. Selikoff today, but what I do have is a picture of his most famous piece of literature. This was in the Journal of American Medical Association, 1964, Asbestos Exposure and Neoplasia. Neoplasia, just a fancy word for cancer. And what this was his report on the followings and findings related to the New York insulators that he had been following, that union up in New York City, and saw the marked increase of asbestos-related diseases, in particular mesothelioma. And what did he do in 1964 after the conclusion of this study? Well, he organized a very swanky meeting amongst luminaries from government, labor, the health organizations, industry. Everybody met at the St. Regis in New York City, I believe, for a period of days to talk about asbestos, talk about the risks, talk about exposures, talk about protecting people. So 1964, that year is kind of the drop dead date where you can no longer deny that you knew or had an opportunity to know about the history or the risk of asbestos exposure as it relates to mesothelioma. This meeting was in every paper. It was in the New York Times. They talked about it. Industry was there. Unions were there. Everybody was there. So it's very important to note that even at that meeting at this time, they weren't just talking about the risk. They were talking about things like low exposure risk and how there's no known threshold, how they don't know how much asbestos can cause mesothelioma. So therefore, you have to protect against all exposures. So this was a very important date in the history of asbestos and asbestos litigation. There's Mr. Burrell. Typically in these slides, presentations, people show Mr. Stevenson, Ward Stevenson, the lawyer. But I found a picture of Clarence Burrell. This is probably taken shortly before his trial. I've seen pictures of him at his trial when he was emaciated from his asbestosis and looked very, very different, but he looks quite a bit healthier here. But like I said, 1969, that was that first asbestos products liability case. 1971, the jury found for Burrell on strict liability grounds. And ever since then, cases have been moving forward through the system. So let's talk a little bit about the creation of bankruptcy trusts. I'm sure a lot of folks are familiar with this as it relates to Johnson & Johnson, or at least tangentially. But this really started in the 1980s and it's continued up until today. Think of the commercials. I don't want to presume anything here, but I imagine almost everyone in this room or listening to this webinar has seen one of those commercials that says, if you or a loved one have been diagnosed with mesothelioma, please give us a call at this number. So those commercials are referring to a couple different things. When they talk about a set of money or a pool of money that has been set aside for victims of asbestos-related diseases, They're talking about the bankruptcy trust system. And basically what the bankruptcy trust system is, back in the 1980s, you had companies, in particular, Johns Manville, they're the first, that realized they were being sued for asbestos at a crazy rate. And they weren't able to operate as a company, at least that was their claim. So Johns Manville, who was the biggest and worst, the baddest of them all in terms of asbestos product manufacturers, like I said, they owned the mines, they were vertically integrated. If you touched asbestos in the United States, it probably had something to do with Johns Manville at some point in time. They filed for bankruptcy in 1982 because they were facing hundreds of thousands of lawsuits. And the bankruptcy court was faced with a unique question. They had to figure out, okay, what do we do in this situation? Because we know of this latency period related to asbestos. We know that there are going to be a ton of people who are not yet sick, who have worked with Johns Manville products, who are going to get sick. How do we deal with that? And what they did is they came up with the 524G trust. Basically, that's a mechanism to allow companies to set aside pools of money to award future claimants related to asbestos injuries and then re-enter the marketplace as a solvent company after reorganization. So Johns Manville was the first to do this. Since then, there have been hundreds of these companies. There's good aspects to this and there are bad. The main problem is limited recovery in terms of settlement. For example, Johns Manville, every single settlement with the Johns Manville Trust is technically $350,000, but that's only on paper. Johns Manville, pursuant to the governing trust documents, pays somewhere around 5.25%. It changes, but I believe that the actual settlement take home is closer to $15,000. Obviously, someone diagnosed with mesothelioma who dies within a year for working with a Johns Manville product, that doesn't seem like very much in terms of compensation. But it does allow people to access compensation a bit quicker with a little less evidence than would otherwise be needed in the traditional tort system. And we'll talk a little bit about some of the recent abuses, but I'm sure everyone has already heard about Johnson & Johnson. Tort reform, there's not much here to really say specific to asbestos. We all dealt with it. We all deal with it. But there are some particular things that happen in particular states. And these states that are listed here aren't to indicate that they're the only states where this has happened. It just shows you some of the things related to asbestos in particular that have happened in some states. And I'm giving an example. For example, Florida has had an asbestos, they call it the Asbestos and Silica Fairness Act, passed. It has all sorts of rules about requirements concerning filings and proof and things of that nature. Other states like where I am, Texas, well, we have a heightened burden of proof. We have a heightened causation standard. We have to show things that other states basically never have to show in terms of demonstrating that a particular defendant's product substantially contributed to an individual's mesothelioma, specific causation. And then there's obviously, or not obviously, but there are also required disclosures in many states that are basically pre-suit or contemporaneous with the suit being filed, disclosures that you have to basically give the other side discovery before discovery actually happens. Why that is the case, why asbestos litigants and asbestos victims should not have the benefit of discovery like every other litigant in this country. I don't have enough time to get into all my problems with these statutes, but they are statutes that states across the country have passed that we have to deal with. So let's talk a little bit about talc. Everyone knows on the left, or at least my left, we have Johnson's baby powder. That's the sort of ubiquitous talc defendant that we've all come aware of. And we've seen their bankruptcies. We've seen the verdicts against them. We know it because it was so common. It was in all of our homes. Our parents used it. We used it on our kids. It was everywhere. So it doesn't surprise any of us that it sort of occupies a very, very prominent place in our minds. But that's just part of the story. Talc was used in all sorts of things and still is used in all sorts of things. On your right, in those burlap sacks, that's something called nitrile. Nitrile was an industrial talc farmed up in the Gouverneur region of New York by a company called R.T. Vanderbilt. Now, I've had trials against R.T. Vanderbilt. They will tell you that they are not related to the Vanderbilt family. I don't believe that. They've owned and operated mines in that area for almost a century. And what industrial grade talc is different than cosmetic grade talc, but they're both contaminated with asbestos. So when evaluating talc claims or the potential for talc claims, we have to remind ourselves that we are not just looking at Johnson & Johnson. That is one of many. There are many other things that utilize talc, and we'll talk about those in a moment. This is just a little bit of information about sort of the trajectory of the mesothelioma litigation landscape recently. As you can see in the top there, we have the asbestos filings by year. Here we see there are 4,100 back in 2018, and it's down to about 3,500 in 2022. And that's not going to reflect much of a change in the mesothelioma filings. What we're seeing less of are non-malignant asbestosis and lung cancer filings. Those are becoming more difficult to file. And you can see under in the next chart where it says annual asbestos filings by disease, that's basically what we're seeing. We see that mesotheliomas are holding pretty flat, pretty steady from 2020 through 2022, increasing a bit to 2.2% or up 2.2%. But it's the other types of diseases, the other non-mesothelioma cases that are certainly decreasing. And there are for a lot of reasons. Like I said earlier, there aren't going to be as many asbestoses anymore. Lung cancers as well are more difficult because they also require a higher exposure than do mesothelioma. One of the things that we need to remind ourselves as it relates to mesothelioma is just the lack or there's no required amount of exposure to asbestos to cause it. We have had studies of individuals working with asbestos for 3 days, and later on they get mesothelioma. It is unlike asbestosis. It is unlike lung cancer that do in fact require sort of a higher burden, a higher dose of asbestos. Mesothelioma, that's one of the things that's so insidious about it. We can be exposed for very short amounts of time and still get mesothelioma. These are some of the main jurisdictions where you see a lot of these cases filed. You know, at Beasley Allen, typically when we get a case, we evaluate the case, we determine whether it can be filed in the venue where the individual was exposed. We try to litigate in the home venue because that's typically what law will apply. But that doesn't mean there aren't other counties and other jurisdictions throughout the United States that have focused on asbestos or have courts dedicated to asbestos, where many of these cases from around the country are filed. The main ones you'll see are Madison County and St. Clair. Madison County and St. Clair are across the river in Illinois, across from St. Louis. They have hundreds or thousands even of asbestos cases filed there annually. And those cases work their way through the system just like any other case. The only difference is they're in dedicated asbestos courts with asbestos judges, basically. Here we have percentage of overall asbestos filings with talc exposure by disease. And this is really important. We're going to see that the increase is happening. Basically, back in 2018, you'd only have about 13% of all mesothelioma cases included a claim related to talc exposure. That's gone up all the way to 21% over the past 5 years. But with that said, you're not going to see that same increase as it relates to the other diseases. And that's because we all agree that if asbestos is contaminated, or excuse me, if talc is contaminated with asbestos, we're still talking about less asbestos than would be in a typical asbestos product. So if you have Johnson & Johnson baby powder, or if you have Nital talc, there's going to be asbestos contaminated in that talc. It's contaminated in there because the talc and the asbestos, they're both minerals. They both form in basically the same location in the same areas. So when you're getting the talc, you can't not get some asbestos. As badly as they want to get the asbestos out of that Nital, as badly as Johnson & Johnson wanted to get that asbestos out of that baby powder, they just couldn't do it. But there still are going to be markedly lower levels of asbestos in those products than, say, pure asbestos thermal system insulation. And because of the lower levels of asbestos in the talc products, typically the exposure level will not be enough to get you to that lung cancer level, to get you to that asbestotic level, but it certainly is enough for the mesothelioma level. Recent bankruptcy abuses. This is the recent trend that we've seen play out quite a bit recently, but it's also something that's been going on that people haven't been paying attention to for almost a decade. Everybody knows J&J. This is probably the 10th time I've brought them up. They obviously have a $400 billion market cap, or a massive corporation who recently not just tried once, not just tried twice, but probably going to try a third time. shield themselves from liabilities related to a product that they knew going back to the 1960s contained asbestos. And instead of deciding to take that asbestos out or take that product off the market, they tried to come up with ways that you could basically not detect the asbestos that they knew was in their Johnson & Johnson baby powder. But other companies have been doing this as well. Certainteed, Saint-Gobain. Certainteed was a company that made asbestos-containing cement pipe. I tried a case against Certainteed shortly before they filed for bankruptcy in September of 2019. And they filed for bankruptcy shortly thereafter. They made asbestos cement pipe, which contained crucidolite. Up until the 1980s, they were making asbestos-containing cement pipe with crucidolite. That same stuff that I said was by far the worst asbestos. That stuff was terribly dangerous, yet a company like Certainteed, who has been in existence since the 1920s, failed to remove that product from the marketplace. But they filed for bankruptcy. They're owned by Saint-Gobain. Saint-Gobain is a conglomerate based out of France. There's no reason whatsoever that a company like Certainteed, operated and owned by Saint-Gobain, needs to seek bankruptcy protection. They did the same thing that Johnson & Johnson did. It's just not receiving quite as much attention. And then we have Bestwall LLC, also known as Georgia Pacific. Even earlier, Georgia Pacific, they owned and operated a company called Bestwall that made joint compound, and they filed for bankruptcy in 2017, claiming that they were not able to remain a solvent corporation in the face of impending asbestos liabilities. Everyone knows about Georgia Pacific. Everyone knows the Koch brothers. They're a very profitable company, $125 billion in revenue last year, yet they sought and are seeking bankruptcy protection for their asbestos liabilities. A couple Alabama-specific considerations. Recently, it has not been a hotbed for mesothelioma filings. And there's a pretty basic rule or reason as to why that is. There's a statute of limitations rule in Alabama that I'm sure many of you are aware of, which basically says that pre-1979, I believe it's May 6, 1979, any exposures prior to that date, the case had to be filed within 1 year. In other words, a mesothelioma, someone who's exposed to asbestos in 1977, would have had to file his mesothelioma case in 1978 for it to be viable. The Supreme Court of Alabama made sure, or the statute changed in 1979, so now it's the discovery rule post-1979, so we're able to bring those cases post-1979. And there are more and more of those cases popping up now. In other words, there are people who were exposed in the 80s and in the 90s, and those are long enough ago now that we're beginning to see those mesotheliomas, and we're able to file those cases. I've litigated 3 in Alabama recently with good success. We have good venues. We have good judges. The law can be tricky sometimes, but if you're able to get past that statute of limitation rule, things are very, very good, or can be very, very good. But the problem was most of the folks who were getting mesothelioma over the past 20 years were exposed pre-1979. Some of the common kinds of exposures that we see in Alabama, well, we have a lot of paper mills, power generating stations, and of course, shipyards. I've litigated paper mill mesotheliomas, and I've litigated shipyard mesotheliomas out of Alabama. And like I said, mesothelioma cases are becoming more viable as time goes by. So these are some of the common defenses that we will hear in just about every single asbestos case. What we have to keep in mind is, I believe David said, asbestos and asbestos litigation is the longest lasting mass tort in the history of mass torts. In other words, these guys have had a lot of time to think about defenses, and some of them are pretty good, some of them not so good. The most basic is going to be a shares responsibility, or sort of an asbestos, but not my asbestos. In other words, defendants will agree that, yes, asbestos caused this person's mesothelioma, but they'll throw their hands up and say, not my asbestos. They'll try to find other sources of asbestos. We call that an alternative exposure argument, where they'll basically try to drum up and look for other exposures, not to their particular product, but to someone else's product, and point the finger at them. Dose, that's something that's become increasingly important in the litigation across numerous jurisdictions. Here in Texas, I actually have to quantify my dose and relate it back to 2 epidemiological studies that show that that particular dose doubles the risk of an individual's mesothelioma. That's a very, very high standard to meet. In most states, we don't have to do that. We just have to show that there was exposure, but the defendants will always argue that the exposure, the dose, the cumulative dose over a certain amount of time was not enough. They've done extensive amount of literature writing in some of the scientific journals, some of the less reputable ones, pushing forward ideas like a NOAL, which is a non-observable effect limit, basically where there is not a level of exposure enough to cause the mesothelioma. Employer liability, empty chair. They're always going to say that it was the job of the employer to warn the individual. They're going to say that this worker worked for this company, you're suing the product manufacturer. It was the job of the employer to warn. It wasn't our job to warn. Alternative causes outside of asbestos. Like I said, there are a few. You can get mesothelioma from excessive radiation, especially on the pleura region. Basically, if you have a previous cancer and you're being treated for a new cancer to the pleura space, sometimes that will result in a mesothelioma. Aragonite, that's another mineral fiber, but it's typically only found in Turkey. They actually made homes out of it in Turkey. So oftentimes we'll be sitting in a deposition with a client, and all of a sudden some defense attorney who thinks they're quite smart will say, have you ever spent, many months in Turkey? And the client will look at me like, that person's crazy. Why are they asking me about my vacations? It's because they're trying to relate back a mesothelioma with some sort of exposure to aragonite while visiting Turkey. And then obviously, or not obviously, but broken rib. If you have a serious broken rib, if you're in a car accident and there's a substantial, severe injury to the pleura space, that can sometimes result later on in a mesothelioma. Other things that they'll argue are a family history of cancer. There's been a lot of research done into something called the BAP1 gene. It's supposedly a predisposition gene that makes people potentially more predisposed to asbestos. Plaintiff's argument is predisposition is not synonymous with causative. In other words, you might be predisposed, but you still need to be exposed to the asbestos. It might just be a little bit less. So therefore, we argue eggshell syndrome all the time, or eggshell plaintiff. Misdiagnosis is common, but not as common as it used to be. I'm facing this in one of my cases right now. Defendants will argue that it's not mesothelioma. The treating physician, the treating pathologist, they're all wrong. That's not meso. Let me tell you what it is. I'm going to hire my defense experts to tell the jury what it is. It's not meso. And when all else fails, what do they always argue? Idiopathic. Idiopathic means just bad luck. It just happened. We can't explain it. We don't know why. There aren't exposures. Certainly not to my product. You don't have a family history. You don't have an alternative cause. Nothing like that. It just happened. It popped up out of nowhere. I had a pathologist expert in one of my cases. Well, she actually is not an expert. She was a witness because she was the treating oncologist up at the University of Chicago, Dr. Hetty Kendler. And she testifies in a lot of these cases because she sees so many mesotheliomas, but she does not work as a retained expert. And on the stand, she was asked about idiopathic mesotheliomas. And she said, idiopathic mesotheliomas are the only time I ever hear about an idiopathic mesothelioma is in a courtroom like this, is when a defendant has an attorney get up and talk to me about spontaneous mesotheliomas, about them just popping up. No one in the medical community, no one in the scientific community respects the idea of an idiopathic mesothelioma, but that doesn't mean that defense attorneys don't try to utilize that defense in cases. So finally, we'll talk a little bit about the future of asbestos and in particular mesothelioma litigation. Mesothelioma cases remain viable, very, very viable and very, very strong. Selection of jurisdiction is going to be crucial. As I showed you, there are a number of jurisdictions that are home to lots of these cases, but that doesn't necessarily mean that it's the right jurisdiction for each particular case. It comes down to the facts, it comes down to the exposures, it comes down to where we can file to get the most value. These cases are still valuable, multi-millions of dollars. I'm sure that you see in the legal reporting of jury verdicts in the hundreds of millions of dollars, 20, 30, 40, 50, that happens every year, multiple times. Obviously, that drives settlement value. These cases are all worth millions of dollars if litigated properly. Take-home cases and premises cases are going to be continually more common because it's less and less likely that folks are actually working with asbestos with a product at a facility, but the likelihood of someone who had been doing laundry or something of that effect as it relates to take-home cases remains. And of course, talc cases. And I mentioned this earlier, but it's very important to keep in mind. We aren't just talking about baby powder. There are very, very many products that utilize cosmetic talc and still utilize cosmetic talc in this country. And not just face powder, mascara, lipstick, foundation, eyeshadow, blush, children's makeup. All of those things use cosmetic talc in one form or another. And all of those things can cause mesothelioma. And not just with the cosmetic talc, but we have the other talc as well: rubber, insecticides, plastics, paper, ceramics, paint, roofing materials. All of those things utilize industrial talc. That's that nitrile material. But nitrile is just one example. There are dozens of companies that utilize this or made this this industrial talc, and they're all a threat. And many of them are still used to this day. And if they're not used, they were only stopped recently. So that's the presentation for today. I'd like to thank you for listening to me. And if anyone has any questions, I'm not sure if I see any, but I'd be happy to answer them.
Charlie, thanks so much. On behalf of everyone viewing today, I want to really thank you for a wonderful presentation. I'm always amazed by the work that my partners do. I think your work is vitally important. I think the clients you represent are some of the most deserving that we as lawyers could ever come across. I do have a few questions for you, if you don't mind.
Go ahead.
Yeah, Charlie, I want to start by revisiting the Alabama-specific considerations you mentioned earlier. Can you go into a bit more detail about the Alabama statute of limitations rule and how it leaves some otherwise deserving plaintiffs without a viable remedy?
Sure. So essentially, my understanding is that in Alabama, the statute of limitations discovery rule was adopted at some point in 1979. I think it went into effect May 6, 1979. Prior to that, there was a 1-year statute of limitations as it relates to personal injury cases. So prior to the way the court interpreted that change is that individuals who were exposed to asbestos, say in the 1960s or 1970s in Alabama, but then later were diagnosed with mesothelioma, because it takes 30 years, in 2000 or 2010. Well, their window to file didn't begin at the point of diagnosis. It began at the point of exposure. So in 1977, when they're exposed to asbestos, they aren't diagnosed for another 40 years. They would have had to file that claim by 1978. When the statute was changed in 1979, obviously that makes it different. So now it's when you're diagnosed and you discover that that diagnosis is related back to your asbestos exposure. But essentially, it made it an impossible situation, because when you have a latency period of 30, 40, 50 years, it's literally impossible for someone exposed in 77 to have any idea that they're going to have mesothelioma in 2010. So for about 30 years, mesothelioma litigation in Alabama was all but cut off. From a practical perspective, what it did is it eliminated the litigation, because every single person was exposed pre-1979. Now, you might have had some folks who had a spillover pre-79 and post-79, and then you could try to incorporate the post-79 exposures, but not the pre-79 exposures. But what it did on a practical level was eliminate the litigation. But now we're to a point that essentially enough time has passed that you have enough folks who were exposed in the 80s or even the 90s that latency period has extended far enough out so that we're able to get these cases and file these cases.
Thanks very much. We have a question from one of our audience members. Sherry asked the question, what was the percentage of plural mesothelioma? I think you mentioned that earlier.
Plural is going to be about 70%. Now, these are all sort of, estimates that depend on which medical journal or medical literature you look at. But plural is predominant. It's going to be about 70%. And then you have the peritoneal anywhere between 20 and 25%. And then you have the rest being pericardial, and then the very, very rare testicular.
All right, very good. I have so many other questions I would love to ask you. I mean, this is a fascinating topic, and unfortunately, we're short on time today, but let me go over a few final housekeeping notes, Charlie, before we wrap up. For those of our viewers who may have missed our earlier announcements, by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link. So those of you who have asked about slides, you will receive updated slides and a video link this week. You can email your completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys who are participating today by phone, it is very, very important that you email us your name, phone number, and state bar ID number. You can send that to webinars@beasleyallen.com. That'll help us ensure you receive full CLE credit for today's program. Also, once again, be sure to check out the events page of our website. That's beasleyallen.com/events, as we're going to be adding a lot of webinars throughout the year. And again, just simply by participating in these webinars, you're going to be able to knock out a really, really big chunk of your CLE obligations for the year. Thanks again to everybody for joining us today. Thank you for supporting our Beasley Allen webinar series. Have a great rest of your day and a great rest of your week. Thanks so much.
Thanks, everyone.